Welcome to today's webinar on patent examination, which is a part of our Applying for Patents webinar series. My name is Fasiha, and I work at SIPO's Services to Business branch in the Intellectual Property Awareness and Education team. And today, we are going to cover how to get a patent by understanding the examination process steps, going over a detailed analysis of patent examination procedures, and understanding how to properly respond to office actions. So today, I will answer the following questions and explain the various and critical parts of a patent, what there is to know about filing a patent, what the difference is between a patent examiner and an agent and what each of them does, as well going over an understanding of the examination steps, including the continuation of the application process once the assessment has been initiated by the examiner, understanding office action and how to respond efficiently, as well as demystifying resorts to enforce a patent. So how can you protect your invention? What is it that you need to know about patenting? Well, before you file a patent application, there are 3 steps that you must take. You must ensure that you know what a patent is, what can be patented, and how to perform a search. Because not everything that exists under the sun can be protected by a patent. So before you file for a patent, you must be sure that it can be patented to begin with. And once this first question is answered and your idea or invention is in the patentable category, you must perform a search to see if someone else has thought about this before you. So what exactly is a patent? A patent is a legal protection provided by the government to exclude others from making, using, or selling your invention throughout the country wherein patent protection was asked. And that is for a limited amount of time, more specifically 20 years from filing, and this is in exchange that your invention will be published for the greater good of promoting innovation. That is what is called the quid pro quo of patent protection. Then there are some parts of a patent that are absolutely crucial. These include the description, so what the invention is about, the claims, which are what set the boundaries of your invention and provide you with a monopoly, and this is the part of a patent where the focus should be, as this is where the meat of the invention resides. And if you want to learn more on patent parts, we invite you to watch our other webinar on applying for patents, anatomy of a patent, to dive deeper into that topic. So a patent is an IP right that protects ideas that are inventions. And for an invention to be patented, it must meet at least 3 main criteria set out in the Patent Act and rules, which are novelty, utility, and that it must be not obvious. The invention must be new, so it must be the first one of its kind in the world, and it also must be useful to do something or perform something. As well, it must not be obvious, meaning that it must be inventive from the perspective of anyone who works in that field of technology. An invention could also be patented for being an improvement made on an existing technology as long as it is, again, new, useful, and non-obvious. So before you patent your invention, you must make sure that it actually has an advantage over what's already known. And to determine that, you must perform a search on all that exists out there. But you cannot do that without first determining the point of invention, the inventive concept, so what lies behind your idea. A search should be performed on this idea of yours before spending money on filing something that's already known. And to learn about how to perform a search, we invite you to watch our other webinar on applying for patents, searching for patents. Today, though, we will see how to properly file an application and get a patent by learning what patent examination entails. So what is there to know about filing a patent application? We will go through the filing process and the importance of getting it right. Let's begin with the filing timeline. Here's a brief overview of the process and the corresponding timeline. Now, we already mentioned that it is wise to perform a search on your invention before engaging in the patent filing system, as per the very first box of this timeline. The following step is to secure a filing date. And to do this, you only have to indicate that you want a patent, provide your information as in your name, and a description of the invention. These 3 criteria are all that you need in order to secure a date. However, in order to actually get a patent, you will need to complete your full application. This means that you will need to provide more information and documents, as well as pay a filing fee. As mentioned earlier, the quid pro quo of the patent system is that in order to get patent protection from the government, you are willing to publish your invention for the greater good of innovation. Which is then followed by examination of your patent application, which is today's webinar's main topic, and to eventually become compliant with the Patent Act and rules, and for you to get your patent granted and maximize the potential to make money out of it. Now, one crucial aspect of the patent system relates to dates. For an invention to be patented, it must be new and inventive. This means that you must be the first one not only to make it, but also to ask for patent protection on this invention. Being the first one to file will also mean that your invention will be published 18 months later. However, you will have to be the first one to ask for patent, and no one later on will be able to do so if one was to have invented the same thing as you. In order to secure a filing date at the Patent Office, not much is required. All you need to say to the Patent Office is that you are seeking to get a patent and provide them with your name and contact information as the applicant. As well, you need to provide a document that looks like you are describing an invention. However, if these documents are not provided on the same day, the date that will be secured as the filing date will be the day when all of these will be provided to the Patent Office. So whenever in doubt about any of these procedures, it is always recommended that you consult a patent agent. A list of registered patent agents is available on the College of Patent and Trademark Agents website. It should also be noted that securing a date is not sufficient to obtain a patent. In order for your patent application to be looked at by an examiner and proceeded to be granted, you will need to complete your application in full. And to complete a patent application, a little bit more information is required than the 3 things needed to secure a filing date, on top of a filing fee, of course. You will need to provide the Patent Office with an official petition for the grant of a patent, so a document that states that you are seeking to get a patent on your invention, the names of each of the inventors and their declaration that they have been involved in developing the invention. On top of the description already provided, you will need to provide to the office an abstract summarizing your invention and claims setting the fence of your monopoly that your patent will confer. You will also need to provide some drawings and a sequence listing if your invention requires those items. And as always, please remember that if you are ever in doubt or unsure of these procedures, it's always strongly advised to consult a patent agent to help you out. So now that your application is complete and you have a filing date secured, what's next? How does the examination of the application work? What is it that you need to know about this process? It is crucial to understand the various examination steps as time is ticking now that you have a filing date. A certain level of protection is awarded when you have a published patent application, but more protection is provided when the application is granted and officially becomes a patent. You must know that patent applications are not automatically examined. Only the ones that request their applications to be examined will actually be examined. The first 2 steps can happen interchangeably depending on when you request your application to be examined, but usually the publication of the application happens first, as there is a 4-year period before you have to request examination, while there's only 18 months from filing for your application to become public. Something else worth noting is that if you don't request examination within the 4-year time period, your application will be abandoned. And I'd just like to point out that if you are interested in learning more about patent abandonment, it is outside the scope of this webinar, but I encourage you to look it up on CIPO's website in the Manual of Patent Office Practice and the Patent Act and Rules. Once the request is made, your application will be looked at by a patent examiner who will then let you know if your application complies with the regulations or not. And if it doesn't, the examiner will let you know of the defect or defects to correct by the way of a letter. There can be a few communications back and forth between you and the examiner at this step of the process, so it's important to remain diligent. And you can either agree with the examiner's findings or not, and if not, you can provide arguments to convince the examiner that your application is proper as it is. Once your application complies with all of the requirements, the examiner will then allow your application to proceed to grant. So let's take a closer look at the examination portion of this timeline. So what is meant by an examiner's action, and what exactly does that person do? A patent examiner is the person who will read all of the parts of your application and make sure that it complies with the regulations. This means that your application not only must be new, inventive, and useful, it must also comply with all of the other requirements of the Patent Act and the patent rules, other than those three. So, first, the examiner will perform their own search to make sure your invention is new, not obvious, and useful. Then the examiner will make sure that the application complies with other parts of the Patent Act and rules. These can be things like the page numbering being consecutive, the invention can be enabled or put into practice, that the description is not misleading, the claims numbering is consecutive, the claims have a clear foundation in the description without referring to the description, that the claims are clear, concise, and consist of a single sentence, that drawings are clear, and the list goes on and on. And once that part is done, if any defects were found in your application, the examiner will write you a report detailing these defects in view of which part of the Patent Act and rules they relate to. And then this report or letter will be sent to you and will allow you a time period in which to provide a response back to the office. You can either agree with the defects found and correct them as asked, or you can disagree partly or completely. And if you disagree and think that your application is respecting the regulations, you will need to provide a response to that effect to the examiner explaining why you think your application does comply. This could be accomplished upon first attempt, but maybe not, and maybe it'll require more than one communication back and forth with the examiner to explain yourself and to come to an understanding. So, this begs the question, what is the difference then between a patent examiner and a patent agent? Who is who, and what exactly does each one do? The difference between a patent examiner and a patent agent basically comes down to who is on which side of the application. One represents the Crown and wants the application to comply with the federal patent regulations, while the other represents a client and wants that client to get the best possible patent involving the widest coverage possible. The examiner is the public or government representative and is the one who will grant the monopoly the government will provide the applicant or inventor in exchange of the publication of the invention. And the agent is the client representative and will defend the patent in court if it ever gets to that level. Each of them have their mandate but must cooperate, come to an agreement respecting the patent regulations for a patent application to be allowed and for the patent to eventually be granted. Now, before we get further into the topic of examination, you must be aware that there are a few things that no one can get around when prosecuting a case. So, SIPO is a bilingual office, meaning that all communications must either be in French or in English. Either one you prefer is fine, but it can only be one of the two official languages. In comparison, the US and UK patent offices only converse in English, while the European IP office accepts English, French, or German as the official languages. Here in Canada, though, it's either English or French. The only step where this is different is when you're securing your filing date. Only at that stage you can submit a document in any other language, but it has to eventually be translated to French or English in order for your application to be completed. Remember, the step after securing the filing date is the completion of the application. So this is really, really important. Then anything you want to be put on file or that has any legal repercussions is in writing. You can call an examiner to discuss a case over the phone, but only what you will be sending them in writing will be made part of the file legally. And no patent examiner will commit to anything over the phone. All of this must be in writing in order to be official. So now let's get into patent correspondence. What exactly is it and how does it work? We'll take a deeper look at office actions and how to respond to them efficiently. So, what exactly is contained in an examiner's report, which is also called an office action? On this slide, you will see an example of the very first page of an examiner's report. First, at the very top, you can find the name of the representative. That is the person or patent agent's firm to which the letter is addressed. This is followed by the application number, who the owner of the application is, the title of the application, a classification code based on the technology this invention pertains to, and a file number given by the applicant and the name of the examiner responsible for the case. Under this information block, you will find the action that is required from you when you get an examiner's report. This request, found in capital letters, is telling you what you have to do upon reception of this letter and under which time limit you have to accomplish this task, which can be 4 months, or which is 4 months rather in this example. The time limit of 4 months is from the date it was sent out, as you can notice on the upper right corner that the report bears a date stamp. Under the capital letter paragraph, there is found an indication as to the content of the patent application in this report. In this example, it is based on the application as filed, so there were no amendments made to the file after it was originally filed and requested to be examined. And in this case, it contains 35 pages of description, 13 claims, no drawings, and no sequence listings. And then you will find that the meat of this report is the defects, if any of them are found. That is where you will learn if your application complies with the Patent Act and rules or not. And if it doesn't, what are the defects that need to be corrected for the application to proceed to allowance and get granted? Then the very last part of an examiner's report is the search report. This is where you can find the details of the search performed by the examiner to evaluate if your invention is in fact new, inventive, and non-obvious. The top of the box shows you on what the examiner has based their search and the date that it was performed. In this example's case, it was based on claims 1 to 13. It then tells you what type of search was performed, a first-to-file search, a comprehensive search, a top-up search, etc. And was it only on the invention, or was there a search performed on the inventors and applicants as well? Here, 2 searches have been performed, an F2F, or a first-to-file, and an applicant and inventor search. In the search history box, you will see that the database was used to perform the search or searches, and you see the search string used and the number of documents that a specific search string has resulted in, and so those were the ones consulted by the examiner. Here, the examiner consulted 220 documents upon the F2F search, and then reviewed 19 patent documents from Stan Lee or owned by Marvel Cinematic Universe. So now that you have received an examiner's report, how do you respond? How can you make sure that your answer will be reviewed properly? You first have to identify the application's representative, then identify by number the patent application that you are providing a response for. Your letter also needs to be addressed to the patent commissioner and not the examiner, as the examiner is the patent commissioner's representative. This is then followed by the letter type, as the patent office deals with more than 600 letters every day. And for your letter to be added under the proper file or course of action, the letter type must be provided and easy to find. This is usually in bold font and easy to locate on the first page of the letter. As per the examination report, it must be identified to what content it is that you are responding to. So here it is the examiner's report of a specified date. This is followed by what it is that you want the patent office to change to your file if you are submitting a full new section, like claims or abstracts, for instance. Or if you are submitting a few new pages here and there, you have to explain where they go. So let's say you had 13 claims on file and you are now adding 2 claims. You want the patent office to delete the whole claim set currently on file in exchange of the new claim set that you are sending along with your response as separate new claims pages. Then this is followed by what you are correcting, so your claim number, description pages, etc. If you agreed with the defects that were identified by the examiner or not, and you provide explanations or arguments accordingly. But really in hopes that you will convince the examiner that you are right. In that way, they can grant you a patent. But did you really convince the examiner with your response? This is where the examination can take one of 2 paths. You will either receive an office letter telling you your application is allowed and that it will proceed to grant upon payment of a final fee or not, which you will know when you receive another examiner's report. So in our example, this new report will bear a new mailing date and a report basis. It will tell you the action that you need to take in capital letters and provide you with another time limit to do so. And if a document was cited against the novelty of your invention in the first report, it might still be appearing on the new examiner's report, depending on if you properly corrected the application or provided a convincing enough argument to the examiner. This first part of the report is then followed by the identification of the defects found in the application as it is found on file at that moment. And if the same defects are still found, longer or more detailed explanations are usually provided by the examiner, to which you can again either disagree or agree and provide amendments or arguments accordingly. And this process goes on and on until the application can comply with all of the requirements of the Patent Act and rules. So let's illustrate this process by way of an example. Let's say you invented an elongation modulator. This modulator is a chemical compound of the imidazoline family. So how will you patent this chemical compound of yours? As per the beginning of this presentation, you of course have to make sure that it fits in the patentable category. And a chemical compound is a tangible product, so it does meet the patentable criteria. In your research lab, let's say you have found that this molecule is useful in modulating elongation of physical members of the body to prevent from reaching a breaking point. So it has utility. The next step is to figure out if someone else has thought of this before you. And at this point, you start looking into library databases, and you find that a certain Dr. Jean Grey and her associate Dr. Monroe are doing research very close in nature to your own invention. So you need to secure a filing date as soon as possible, ideally before they do, or before they publish an article on the same molecule or a very close derivative as yours, because in that case, if that happens, you might not be able to patent your invention. So your next step is you draft a description about your invention, provide some claims on the compound itself, its use, and on a plant extraction process, as your secret ingredient is that it comes from a plant, let's say. For an even better endeavor, you hire a firm called Mutant Advocate to help you in this process. They then fill the petition form and submit all of the required patent application parts for your invention to the patent office. So this brings us to asking the question of what must a patent fundamentally have? So all patents anywhere in the world are written the exact same way. All of them must comprise a title, an abstract, a description, and one or more claims. These two sections, the claims and the description, are also referred to as the specification of the patent. Then, some inventions can be illustrated by way of drawings, and when this is the case, the patent must comprise of these drawings. Similarly, some biotechnological inventions comprise sequence listings or require the deposit of biological material, and there are specific regulations to consider for those cases. And one of the patent requirements is that all of these parts start on a new page and follow the proper writing format and layout. There is also a manner and order to present these sections of a patent. All of these requirements are found in the Canadian Patent Act and rules. So for your patent application to be completed, you must submit all of the required parts and secure your invention by drafting proper claims, as it is these that are setting the monopoly of your invention. So now that you have provided all those parts to the patent office, what is your next step? As per the examination timeline, you request your application to be examined as soon as it gets published, and not long after, you receive an examiner's report. So now we're at the yellow oval part of the timeline. As was expected, since you had also found the same researchers' names in your own search, the examiner has found two patent documents published earlier, one of which is by Dr. Gray and Dr. Monroe. While discussing this with your patent agent, you let them know that you had found these researchers as well, but you were convinced that your invention is different than what is being described in the paper cited, and you want to explain why. So together, you decide on the proper response to provide to the examiner in view of the identified defects, and your agent will then draft the response and send it to the patent office before the time limit is up, and will respect all of the requirements to submit a response, which are, again, page numbering, proper margin sizes, instructions on substitutions of pages that are already on file, etc. Other than the novelty defect, other minor defects have been found that you agree with the examiner in that they do not comply with the Patent Act and rules, and you will submit modification pages to fix these minor issues on clarity of claims and support within the description, let's say. In the response, the agent argues the lack of novelty as per your suggestions, mentioning that document D1 is about a different molecule type that bears a different use. The agent also argues that D2 is about a different process than the one that you invented, in the way that the process is run. V2's process requires heat, while yours is a cryogenic process. And once the response is sent to the patent office, you can only wait and hope that the result will be a letter saying that your application was approved and that your patent will get granted as it now complies with all of the legal requirements according to you. Otherwise, you will receive another examiner's report explaining what remains to be fixed in your patent application. And should you agree with the examiner, again, you comply. And if you don't agree with the examiner, you can write a response explaining why you think your application does comply with the legal requirements and the process continues. For the sake of this example, though, let's say all parties are in agreement. The claims are perfectly worded and all other parts of the application do comply with the Patent Act and rules, which is incredible because this means that your application was approved by the examiner. In this case, you will receive a letter from the patent office telling you that your application was allowed, and the last step for you to receive your patent is to pay the final fee. And then you are right at the cusp of full patent protection, which means that you can put your invention in manufacturing or production, you can sell it, use it, and so the potential to make money out of it opens up completely. But now, how can you maintain your patent and make sure that no one else copies your invention? So this leads us to discuss enforcement of a patent. Let's demystify some resorts that you can take to enforce your patent. So once your application is granted, what happens next? Then it falls on you, the patentee, to enforce it and maintain it. There are ways to help you do that, and the federal government is providing you with legal recourses since you have patent protection. You can monitor the market for similar products that might infringe on your patent rights, and you can use monitoring tools online, consult patent examination online, visit patent databases, and see if other patents close to yours exist out there and what documents were cited against them for novelty or obviousness issues. And you can also monitor publications of authors or researchers, like in the example, Dr. Gray and Dr. Monroe, using websites such as Google, where you can set up Google Alerts in Google Patent or Google Scholar to remain aware. The most important thing to know, however, is to respond to infringement when made aware. Act on it and report it. You can also contact SIPO or an IP firm. SIPO's website has tools and different methods of guidance to help you if this ever happens, as shown on the slide. And IP agents, IP litigators can also help you file court orders to protect your invention. So what else do you need to consider in this whole process? Well, understanding the examination history and its impact on patent litigation can save you lots of trouble. If your patent ever faces a court challenge, it is useful to know that anything that was said between the examiner and you or your patent agent can be looked at by the court. So let's say the examiner argued that your application lacked novelty and that somehow you managed to convince the examiner otherwise, and the application was then allowed with that breadth and scope. If the court challenge is on the same topic, so lack of novelty, the judge could very well side with the examiner and not you after reviewing the examination discussion that happened between them and the applicant. And when dealing with legal action, it is always strongly suggested to be aware of repercussions and their impact on later decisions to argue or correct an application following an examiner's finding. Everyone is human and can make mistakes, but amending an application without arguing could be seen as an admission that the examiner was right. And the other way around as well, arguing a defect when the examiner is right can be taken as an attempt to bury other issues. So overall, it is strongly suggested to consult a patent agent or a litigator whenever in doubt, as they can help guide you through successful and unsuccessful strategies. So you might be wondering if there are any other recourses available once a patent is granted. Well, yes, there are, and we will discuss three of them. First, we have the disclaimer. A disclaimer is a renunciation of subject matter. As a patentee, you can file a disclaimer saying that you don't want a certain patent protection anymore. It could be a single claim in part or whole. It could be more than one claim or a claim type, for example. A disclaimer is also a clear and unequivocal statement that the claims of the original patent are too broad and therefore invalid. Though following a disclaimer, the remaining claims are deemed to be valid. Then we have re-examination. This procedure is limited to issues arising from published documents, so prior art that's provided to the patent office. A requester, which can be anyone, the patentee or someone else, can file for a re-exam anytime during the lifetime of a patent. This person explained that a given patent is not proper in view of the documents disclosing information that could lead to an invalid patent in raising a substantial question of patentability. The patent is looked at by the Patent Office in view of this patentability question and evaluated if such a substantial question was raised, and then if the patent requires some claim corrections or not is determined. Now on to the third recourse, which is a reissue. A reissue is a mechanism for correcting a defective or inoperative patent. So let's say that you've instructed your patent agent to limit the expression writing means to quote unquote pencil solely, that the agent forgot to do it and your patent was granted with the broader language. A reissue is a way to correct this defect that once you found it and it can be proven that it was made by mistake. One thing to note is that a reissue must be requested within 4 years from the grant of the original patent. Also, it should be noted that the granting of a reissued patent is a discretionary measure and might not be allowed by the Commissioner of Patents. Once more, whenever you are unsure of the proper course of action, it is strongly advised to consult a patent agent or litigator. So, to wrap up, we have seen how to file a patent, the difference between a patent examiner and an agent. We've gone into detail about the examination steps, office actions, and how to respond, and we've seen what enforcement means. And overall, this concludes the webinar on patent examination. I hope you learned and enjoyed this presentation. And to learn more about other topics related to intellectual property, I invite you to watch our other videos and register for any live webinars on our website. Again, please don't hesitate to contact us if you have any questions or need help finding any of the resources that are on our website. You can reach out to us via the contact information that you see here on screen. You can also contact our intellectual property advisors for a more specific and tailored discussion to your needs by scanning the QR code. And for general questions about IP, you can reach out to our customer service center by phone or by email. All of the information is also provided on screen. And I invite you to follow us on social media. We are on Facebook, YouTube, LinkedIn, and X. And finally, I also recommend exploring the CIPO newsletter titled IP for Business News, where you can find more information about IP products, seminars, webinars, upcoming events, updates to the CIPO website, and many more items that are in the works. Thank you so much for watching and have a wonderful day.